Did you know you can bypass rent with just a little creativity? Get ready for some next level nonsense. Introducing Sovereign Housing Agency, where paying your mortgage or rent is purely optional. Signed a lease but decided you'd rather not pay? No problem. Our expert team will show you how to file endless, frivolous motions, declare your property as tribal land, and insist that the courts have no jurisdiction over you. Fed up with eviction notices? Just ignore them. At Sovereign Housing Agency, we turn every legal loophole into your personal right. Why move out when you can stay put and live rent-free? Our satisfied customers say, eviction? Never heard of it. And remember, your lease is just a suggestion. So what are you waiting for? Call now and learn how to never pay for your home again. Because it's not just a house, it's your sovereign kingdom. Sovereign Housing Agency. Squatting rights for everyone. Live sovereign, live free. Backed by UCC 1-308 and UCC 1-103. Evening, we are on the record tonight for sentencing. We are on the record. Can we get all appearances? Please, everybody, I need your appearances tonight. How's everybody doing? Wanted to say hello to everybody in the chat tonight. Hope you enjoyed that commercial because I know some of you asked for it normally within the stream. So there it is. I get it out the way because we got a long night ahead of us again. All right. So those of you who like to snack, go get your snacks, go get your drinks. We all in tonight, and y'all was all in with me last night. We're gonna keep following this case. I'm enjoying it. So let's see what we can do. Let me go and put myself on the side over here for a second. Oh, this is the moment we waiting for. Look at old Margie over there. All right, y'all ready to do this? Y'all are ready to do this? We got a long way to go. Or for those of you who may be cold, get your blankets, whatever. But we sitting for a while. All right, let's go.
Case number 2025-1045. This case is here for sentencing. And I just want to briefly highlight where we are in the process. Back on July 3rd, there was a trial that was conducted by me. That time, defendant was found guilty on 2 charges, trash accumulation prohibited and storage of or disposal and screening of trash. We scheduled this over for sentencing for today's date. There has been a series of emails that have been submitted to the court in the last 48 hours or so regarding the case. But I will note that it's been on the docket since July 3rd. All parties were aware that the sentencing would go forward today. Earlier today, I ruled on a request by the defendant to either shorten the time for subpoena waivers to be issued or subpoenas to be issued to individuals or continue the hearing. And I denied that request. It was filed fairly late, understanding that there was perhaps an issue that the defendant was concerned about as to an exhibit that was tendered to the defendant that the prosecution intended to admit, having to do with perhaps testimony from someone or a written statement of someone. And if I'm reading correctly, the motion to continue or the emailed motion to continue, it was based upon wanting to secure actual testimony from that individual so that there could be cross-examination in connection with any statements that are made. And so in my order denying the request to continue the hearing or to shorten the period for subpoena waivers, I just don't have the legal authority to shorten the period for someone to respond to a subpoena that is issued. And that's to protect the individual. If an individual is subpoenaed at the last moment, it's not fair to that individual to have to change their lives and have to come to a trial. And so it wouldn't be appropriate for a judge to simply shorten that period, especially to make it shorter than a day or than it would ordinarily be. So I was not comfortable doing that, but also recognizing that because of the fact that there may have been a written statement submitted by the prosecution to the court, at a fairly late juncture. Neither party was given a deadline by which to submit documents, so nobody's done anything incorrect or violated any court rule. But nonetheless, a circumstance that arises when someone wants the court to consider a statement of another person puts another person in a position, the defendant in this case, of not being able to ask questions of that person. So what I'm going to do now before we start the hearing is I would like for the defendant to articulate to me what statement it is, whose statement it is that we're wanting those shortened subpoenas, certain timeframes to be issued.
Your Honor, thank you. Can you hear me?
I can.
Okay. There's two issues here. The first one is that the prosecution refused to let me know who the alleged people who were making complaints about my property were. And there wasn't enough time between my learning that there are all these complaints and the time of the trial for me to actually get subpoenas. Earlier, I had been told about the vague complaints that I could go, that the prosecutor would not give them to me, but that I could go get them from the police department's records. However, the police department's records require 2 to 3 months to get to me, to actually get the information. And there wasn't 2 to 3 months before my trial, so that I could not I didn't know who they were, and I couldn't issue subpoenas. I only learned of the existence of these 11 people who sent written testimony on Monday afternoon, 2.5 days before this trial. And obviously there is not enough time for me to even think about getting the subpoenas out. And so I have been denied the opportunity to respond to what I will hold in my statement are grossly exaggerated accounts of what the condition of my yard has been for years and years, exaggerated amounts of time, as well as considerable inaccuracy or at least disagreement with what actually has happened in a number of incidences occurring on or near my property. I think these are of material concern because they create an extraordinarily damning litany of problems with my property, which I think are blown all out of proportion. I admit there's a problem. I always have, but not this degree of a problem.
So you're saying that there have been 11 potential written statements?
Yes, I have actually gotten copies of those 11, but I didn't get them until Monday afternoon. And that is because there was an indication of exhibit sent to me when the witness name that was going to be called was sent to me, and that was last Friday. But which is still too little time to actually be able to subpoena. But that exhibit, which was the written statements, was not attached to that. And so therefore I was not able to get it until I contacted Ms. Mahoney, and she was able to locate it, and I then got it.
So let me make sure I understand that. So a witness who was identified in a disclosure from the prosecutor who is going to testify, there had a written statement associated with that.
In addition, there are these written statements.
From others.
From 11 others.
And so this person is the 12th. I don't know if male or female, but this person would be the 12th.
No, this person is Jason Strauss.
Okay. And is Mr. Strauss here or appearing by Zoom video?
He's appearing by Zoom video, Your Honor.
And so and Mr. Altenberg's responding to my question. So Mr. Altenberg, so Mr. Strauss had provided a written statement that you then had attached to your disclosure, is that correct?
No, Your Honor.
No.
Okay, why don't you share with me what occurred with Mr. Strauss?
Your Honor, Mr. Strauss is testifying today to his own statement and questions about his own experiences. I believe Ms. LeCompte may be referring to the fact that Mr. Strauss's significant other, Ms. Laauo, has submitted a statement that is part of the group.
That's good.
So a separate individual significant other.
And so you identified Mr. Strauss on a Friday disclosure that he was going to be a witness at the sentencing hearing.
Your Honor, during the Friday disclosure form, we disclosed the two witnesses that we intended to call, the exhibits that we intended to provide, including which one of them was listed, the Exhibit 11, that being the impact statements. In addition to that, we provided all the information necessary and uploaded them on the first.
Unfortunately, that exhibit with the 11 statements in them was missing from the email that I got from BDesk. And I did not get it. I had to ask for it, and I did not get it until the following Monday.
And did you just not attach it, Mr. Altenberg, or what happened with that?
Your Honor, it's my understanding that all of the exhibits that we've provided were uploaded on the first. And in fact, if you look at the full court.
No, uploaded. I'm not talking about uploading. I'm talking about sending to the defendant.
I contacted a paralegal as a response to this allegation, and she provided me with the information that she did send all these out on the first. It was our understanding that all of these were provided on the first, including the Exhibit 11 in question. It wasn't brought to our attention that the Exhibit 11 was not possibly attached until we were provided this information by Ms. Mahoney earlier this week.
And is that accurate in your own investigation, that in fact it wasn't attached to the disclosure that you sent out?
I have not seen any evidence of the lack thereof in my investigation.
And so that's you all are sending that from your own email, correct? From either yours or Ms. Keller's email?
Ms. Keller, the way, to my understanding, Ms. Nicole Keller sends out this information. She does it through full court. She uploads it and then sends it through the full court entity.
I am sorry, it was not there. If it had been, I definitely would not have contacted Ms. Mahoney to ask for it.
In addition to such, Your Honor, if I may respond to some of the statements that Ms. LeCompte has brought up.
Now let's pause for a moment so that I can, what I'm doing is looking to see if I can see the emails that were originally sent from the prosecutor's office. And Sabrina, a quick question for you. Would those show up? Because I'm not seeing anything other than it was sent on July 3rd that's come from this full court's email.
So I pulled up emails on your other screen to show, I think, what they're talking about. This one that I'm highlighting right now is the one that was sent by Ms. Keller. And then you would see which documents may be attached there. And then this is the one that I sent on the 4th.
Okay.
With Exhibit 11.
All right, thank you. Okay. I've done some research here into our system to determine what has occurred. And I'm going to lay clear on this particular concrete issue. We can talk about other issues in a moment, but on this discrete issue that's before us right now, what occurred on August 1st was paralegal from the city attorney's office did send an email to Ms. LeCompte. And in that email, it said, please see attached, and it had exhibits 6, 7, 8, 9, and 10. Exhibits 1 through 5 were part of the presentation at trial, so they were, I believe the prosecution was starting with its exhibits, beginning with Exhibit 6. And then it referenced Exhibit 11 in a pretrial disclosure, but Exhibit 11 was not contained as an attachment in that email. It shows Exhibits 6 through 10 and the city's pretrial disclosures. Exhibit 11, I've looked at it. I have not read it, but it is a number of statements, written statements that were compiled into one document, considered a victim impact statement, but it's a number of individuals who had provided their own written history surrounding this particular property. The pretrial disclosures, although they weren't required as part of sentencing, certainly would have been expected that the parties would have disclosed what they anticipated utilizing at a sentencing hearing. But because those were submitted last week and gave the defendant certainly proper notice of the photographs that were going to be utilized, and that's what is primarily depicted in Exhibits 6 through 10. The people also in their pretrial disclosures identified the witnesses that they would have to testify, which includes Officer Cochran, who is here in the courtroom, and Mr. Strauss, who was participating by Zoom video, but also had the phone number and the email address for Mr. Strauss. That was done on August 1st, which is last Friday. All of that documentation, in the court's view, it was appropriately provided to the defendant in a way to allow the defendant an opportunity to address those issues. What was not provided to the defendant, and I'm not casting aspersions on anyone, but Exhibit 11 was not provided by that email that was sent out by the paralegal. It may have been an oversight. It may not have not been ready. Who knows? But it's not contained here. There's no evidence to indicate that it was sent to Ms. LeCompte, and Ms. LeCompte has made clear that she did not receive it until she did some follow-up with Ms. Mahoney, who works for the court, and Ms. Mahoney was able to secure that. It's not the court's responsibility to exchange documentation with parties, but Ms. Mahoney took it since she had access to it. She was able to, because she did see it perhaps in the system, and was able to send that to Ms. LeCompte. From the court's perspective, from a due process perspective, to be fair to the parties, and in this case fair to the defendant, it's only fair when they have some notice that they can work with when information is shared with them. The municipal court is different than the state court. State court has very specific guidelines. Municipal court rules don't have those types of guidelines, and so there isn't an obligation a specific obligation on a party, and it really just comes from a constitutional what's fair approach that the court has to take. And from the court's perspective here, what's fair is to have put Ms. LeCompte on notice as of when the pretrial disclosures were sent on Friday, so that she would know which witnesses might testify. She's on notice that Mr. Strauss would testify. She's on notice that Officer Cochran will testify, and so they'll be allowed to testify. She's on notice as to exhibits 1 through 5, which she's already seen at the trial, and exhibits 6 through 10, which were provided to her on August 1st. Exhibit 11, which is obviously very lengthy, and it may be important to the prosecution for Exhibit 11 to be utilized, and for those voices, even if it's just written statements, to be considered, will not be part of this hearing if it goes forward today. So I'm going to give you, Mr. Altenberg, an opportunity to stop and think about that and decide whether you'd like to proceed without having the court have the benefit of those statements. There's a number of statements. I think I've heard perhaps as many as 11 statements that are combined in that victim impact statement, which is your Exhibit 11. Exhibit 11 would not be admissible because the amount of time that was given, in fact, it was never actually provided by the prosecution to the defendant. It was provided by the court to the defendant. So the court would not feel that it would be fair to allow those written statements. There's a lot there. I'm quite certain there's a lot of information from a lot of people who have an interest in the court hearing that information. So we can continue this over for 2 weeks to allow adequate time for Ms. LeCompte to serve those witnesses with subpoenas so that they can come and testify, or to at least be able to review their written statements and provide her own rebuttal to it. But at this juncture, I would not consider what is considered in Exhibit 11 if the hearing goes forward today. I've already said I'm denying the motion to continue. I would reconsider that if there was not an objection and the prosecution wants to be able to have the court have access to that information as part of the sentencing hearing. I have shared with the parties on numerous occasions that my focus in sentencing will be the violation that occurred. The court has now found the defendant guilty of violations that occurred on, I believe it was March of 2025, and I don't know the exact date, but the summons would have that. I'll pull that up real quickly. This was from March 5th of 2025. So what I will be considering is what the city has proven beyond a reasonable doubt occurred on March 5th. And then I will be considering the state of the property as of today's date. Those are the two things that I laid out for everyone as being the most important things to the court as far as sentencing goes. Obviously, prior history, the fact that the defendant has a prior case with us for the front part of that property is certainly relevant to the court. And it would be relevant for the court to hear how the circumstances that arose prior to the city initiating an action in the case. But I do have a lot of other information that I will already be getting access to either through the trial that I've already heard or through testimony that's offered here today. So Mr. Strauss can testify. Ms. LeCompte can ask questions if she chooses to do so. Mr. Officer Cochran can testify. Ms. LeCompte can ask questions if she chooses to do so. Any witness that the defense wants to offer would be allowed to testify, and they would, of course, be subject to cross-examination.
We shouldn't be talking about witnesses anymore. This is sentencing day, eh? Why are we going back?
So let me turn to you, Mr. Altenberg. You're the one that has to act on behalf of the city here as to whether you want to continue this case for a couple of weeks so that you could have the court consider Exhibit 11.
Your Honor, if possible, can we argue for the admissibility of Exhibit 11 despite the...
You can certainly make an argument, make a record, you bet.
Yes, Your Honor. I'd first like to state that the defendant argued that these complaints in question were items that we say that we couldn't provide the names of, and that she would be able to obtain this through public records. This is something that she noted in the previous trial, Your Honor, and I believe she is misinformed about what these statements are. These are not the express complaints to the city or to the code enforcement officers, which she originally...
Objection?
Let him finish his sentence at least, and then you can make your objection.
Yes, these are not the complaints filed to the code enforcement office requesting action taken towards the 290 property address. Rather, these are statements provided by the neighborhood, generally speaking, about their overall relationship with the address and the impact of the ongoing noncompliance with themselves.
I understand that. So you wanted to make a comment. Go ahead, Ms. LeCompte.
Yes, I object to this because that is not what I was asking for. I was not asking for the statements of, back when I asked for the names of the people who had made complaints, that was in response to what was introduced in court as hearsay evidence, a vague statement about many, many complaints that have been made about this property. And I brought that up at trial. And I said, as long as I don't know what the specifics are and I don't know who the people are, it's merely hearsay. And that's why
I believe I sustained the objection, and I didn't consider anything relating to people complaining about the property. The evidence that the court considered in determining whether you were guilty or not was evidence that was submitted at the trial by witnesses that actually testified or through exhibits that were introduced at trial.
Yes, Your Honor. But
Thanks, Rebecca. That's a good idea. Wonder how many objections we're going to get tonight.
I wanted the names of the people who, or at least the identity of people who had made complaints so that I could subpoena them. And that is to discuss what their complaints were. And that is what the prosecution would not give me and told me to go to, Chris Reynolds told me to go and talk to the Department of Police Records to get that. And that is what would have taken more time than elapsed before the trial would be held. Therefore, I could not do it.
Okay, and at this juncture, that's not the issue. That's not what the court's making a determination on. What I'm making a determination on is whether or not for this particular hearing, the sentencing hearing, you were put on adequate notice of what was contained in those 11 victim impact statements. And I've just found that as for this sentencing hearing, if it's going to go forward today, that you weren't put on adequate notice of what was contained in those 11 written statements that are part of Exhibit 11.
Okay, thank you.
I found that already, yes. So I've been turning to you, Mr. Altenberg. I've heard your argument. I don't know that it changes my view of things. My view is that it's not enough time for a defendant to be getting something on Monday or Tuesday of this week for a Wednesday hearing.
Your Honor, in addition to this, I paused due to her objection. May I continue with my
Yes, go ahead.
Your Honor. I'd first like to respond to the objection by stating that, as mentioned before, these are simply impact statements. Those who provided them may not have, or at least I'm unaware, if they've ever filed official complaints with the city. These are just personal knowledge statements about their relationship with the property. Secondarily, Your Honor, as noted by yourself and by Ms. LeCompte, she said that she wasn't aware of the existence of this generally until Monday. Your Honor, as noted before, the disclosures form did note the existence of Exhibit 11, did expressly state what it was, that it being a file containing the statements of victim impacts. In addition to so, it also explained the dates in question of when they were
Objection.
obtained voluntarily. Your Honor, as noted before, as well as to address Ms. Lecomte's complaints, she did note that during the previous trial that she requested all the names of those that filed complaints as noted in the exhibit form, the disclosure form, Your Honor. These statements were provided voluntarily after the date of the trial, so they are not relevant to the previous complaints trial made as well.
Objection. All right,
Yeah.
I'm sorry. I find this, first of all, really irrelevant to get to the points at hand, which is the condition of the property and sentencing me. The second thing is, no disclosure information that I got was a short memo, and that is what I received last Friday, that said that the disclosure was that there would be two witnesses called, Officer Cochran and Mr. Strauss, and that there would be exhibits, photographs, and then the 11th one was this attachment, which it consisted of, once I got it, the 11 written statements by people who had been solicited, according to what they actually said, by Mr. Altenberg and by another neighbor, and to provide a testimony in this particular hearing. So I had no advance information as to the content, the format, or even the names of the people, or anything about that. It was an absolute bombshell when I got it on Monday.
And I understand that. So let's cut this part of the conversation off at this point, because the court's already ruled that if the hearing goes forward today, the victim impact statements, which are part of Exhibit 11, will not be admissible. That said, if the city wants to withdraw its objection to continuing this over so that those 11 statements can be considered at the sentencing hearing, the court would be amenable to continuing. If not, I'm ready to move forward and simply wouldn't consider that one exhibit.
Now, I see that about the drinking game in the chat and trying to throw me in there. I'm not paying for the hospital bills. If you start that drinking game, it's on you. It's not on me.
Your Honor, we have more things to comment about that exhibit and why it should be admitted nevertheless. But with that being said, seeing as you have already ruled on the matter, and any mention would be for the record purposes only, the city's more than willing to pursue the hearing today without the Exhibit 11 being admitted, seeing as that's the ruling and that's the justification.
Okay, good enough. So we'll go forward. Exhibit 11 won't be considered. Mr. Strauss, Officer Cochran will both be allowed to testify. You'll be allowed to cross-examine them. Other exhibits will be tendered and admitted as appropriate, but the one that I said was just basically from a discovery perspective, hadn't been disclosed in a timely manner in the court's view from a fairness perspective. And again, I'm not criticizing the prosecution's office. I'm just saying that from a readiness perspective for a defendant to have something not provided at least 4 or 5 days in advance is problematic. So in this particular circumstance, that won't be allowed, but we will go forward with the hearing. So let's turn to that now.
Your Honor, because I had not seen even any kind of hearing like this before, would you be so kind as to sort of give me an idea of the order of business?
Yes, that was going to be my next step. So I'm happy to share with you how this process works. So the defendant's been found guilty of the charge. The court in sentencing can consider everything that it's already heard at trial. So exhibits that were admitted, any testimony that was offered that the court has a memory of or has notes about, I will be considering from the trial itself and the charge that you were found guilty of. And then I can consider any additional evidence that's pertaining to the house itself and any history that's appropriately been disclosed and that's provided by the prosecution. The way the process will work, the prosecutor goes first. He'll have the opportunity. I'm going to give you a chance for about a 2-minute opening statement, or what I call an opening statement, basically to summarize what you think the evidence will show. It's not a full trial, but if you want to make a brief highlight of what you want me to be considering, that's perfectly fine. And then we'll turn to actual and additional presentation from a perspective of evidence presentation for the sentencing hearing. The prosecution will go first. He'll call witnesses that he'd like to have testify. You'll have a chance to ask them questions, very much like the trial that was conducted previously. Any exhibits that he wants to offer, he'll lay a foundation for, just like the trial. If there's an objection to those, that can be rendered by either side when one side is offering an exhibit. And then any exhibit that's been introduced and accepted by the court will be considered the final determination of the sentencing. After he's done presenting his case and presenting his sentencing argument, you'll have a chance to present your sentencing perspective. So if you want to testify as far as sentencing goes, you want to call someone else to testify, you can. If you have exhibits that you want to offer, very much like a trial, it's a different stage of the trial proceedings.
Okay, thank you, Your
You're
Honor.
welcome. Any questions before we get started from here?
Well, I don't understand, will I be able to make a statement other than brief introduction of what I think the points are, in terms of essentially how I see the case the condition has evolved of the case, and call it.
Surely-
Laauo as a witness.
You have the right to call yourself as a witness if you choose to. You have the right to call Mr. Laauo as a witness if you choose to. You're not required to do either, but anybody you call as a witness would have to be subject to cross-examination. Means Mr. Altenberg can ask that person questions. And any evidence that gets admitted, that's been admitted at the trial or that gets admitted during this hearing, both sides can make arguments at the end, if after all the evidence has been produced, based on the evidence that's been produced and accepted by the court, people can make argument as to what the sentence should be. So Mr. Altenberg can argue, I think the sentence should be X, Y, and Z. You can argue it should be whatever you think it should be. And you can point to the facts that's been already introduced at trial or that gets introduced during this hearing.
Okay, thank you.
Well, this is a sentencing hearing. It probably doesn't seem like it, but yes, that's exactly what it is.
All right. Anything else from either side before we get started?
Your Honor, for the purposes of producing evidence in court, I know that the rules of evidence do not apply generally, for the most part, in a sentencing hearing, based off the Carter rules of evidence. When it comes to finding the admissibility of photo evidence, what kind of foundation do you believe is pertinent, necessary to admit it into evidence? And furthermore, when having witnesses testify, what background information do you believe is pertinent for the purposes of getting them sworn?
I recognize that a sentencing hearing is different than a trial, but in my perspective, it's just frankly more efficient for the parties to just lay a quick foundation and move from there. And so I wouldn't change that standard. And I think it's easier for you to ask those basic foundational questions. Who took the picture? When was it taken? What does it represent? Okay, anything else?
Yeah.
All right, let's go ahead and get started. First witness for you, Mr. Altenberg.
First, Your Honor, you did mention we had the opportunity to give the 2-minute opening statement.
Yes, if you'd like to give it, yeah, I forgot about that. Go ahead.
Yes, Your Honor, the people would like to state that the evidence today shows that Ms. LeCompte wasn't in compliance, as noted already, on July 3rd, and as of July 31st, and as of August 4th, we have evidence showing that she is still not in compliance, that there are items still throughout the property, and in addition to that, Your Honor, new items have also been added to the property. You'll hear testimony today from Officer Cochran, who was able to provide these photos to us. In addition to that, you'll hear testimony from Officer Cochran, who will testify to his conversations with the nearby facilities manager of the United Methodist Church, who expressed their opinions and frustrations with the storage of items from 290 Pawnee on the church parking lot as well, in addition to moving items around altogether. In addition to this, Your Honor, you're going to hear a testimony today from Mr. Strauss, who will testify to not only his personal frustrations, but also the frustrations that he knows personally about from other neighbors generally, the annoyances that they've had to deal with this property, and the ongoing non-compliance's effects on himself and his family. And as such, Your Honor, we hope that the evidence today shows that you should sentence Ms. LeCompte accordingly with the sentencing recommendation we intend on filing today.
Thank you for that, Stromberg. Ms. LeCompte, brief opening statement.
Your Honor, I would like to acknowledge the distress that the condition of my yard in the past 3 years has caused to my neighbors. And I want to apologize deeply for my failure to keep the property in as attractive a condition as the rest of the neighborhood. I'll talk about the extenuating circumstances in my statement later. And I want to let you know that I am committed to removing all of the offending trash and I am committed also to making sure this won't happen again. I realize that the cleanup has not been completed as expected, as I had expected. While the front yards and side yards are done, the backyard is still a work in progress. However, I will be describing in my remarks later that I have a plan for actually getting this all done. I've encountered significant obstacles in getting that done, which I regret. And I regret my inability to overcome them. But all I can say is that I do acknowledge the problem, and I do fully commit myself to making sure this never happens again.
Okay, thank you, Mr. Crump. First witness for the prosecution.
Yes, Your Honor. The people would like to call Officer Benjamin Cochran, please, who's appearing in person.
All right, Officer Cochran, if you'll come forward to the witness area, I'll swear you in. If you'll raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you, sir. Whenever you're ready, Mr. Altenberg.
Hello, Officer Cochran. Can you please state your name and spell your last name for the record, please?
My name is Benjamin Cochran, Cochran.
And what is your occupation, Officer Cochran?
I'm a code enforcement officer for the Boulder Police Department in the city of Boulder.
Can you briefly describe your jobs and duties and responsibilities as a code enforcement officer for the city of Boulder?
As a code enforcement officer, I am tasked with the investigation and enforcement of the city's municipal codes, primarily pertaining to property maintenance standards and sanitation codes such as trash storage, weeds, noxious weeds, other property maintenance codes that the city has.
And how
Real quick, Tess, thank you for the super chat. I really appreciate it. Thank you. Thank you very much.
long have you been a code enforcement officer for the city of Boulder?
I've been a code enforcement officer since July of 2019.
Officer Cochran, were you on duty on July 31st, 2025?
I was.
Did you visit the 290 Pawnee address on July 31st, 2025?
Yes, I did.
What did you see when you visited the 290 Pawnee address on July 31st, 2025?
When I arrived at the property, I observed that there were several vehicles parked in the driveway of the property on the Pawnee side. I also observed there to be items which had not been there prior on my recent visit before that. I also observed there to be some vehicles and other trailers in the street adjacent to the property. That's what I was able to see from the public right-of-way adjacent to the property.
Did you take any photos when you visited the 290 Pawnee address on July 31st, 2025?
I did.
What would these photos depict?
The photos that I took will depict the exterior of the property. There were photos taken of the west side of the property along Pawnee Drive. There would also be at least one photo of the yard on the north side of the property. And then I also took photos from an adjacent property, which would show the current condition of the backyard at the time that the photos were taken.
Your Honor, at this time, I would like to show the witness what has been marked as People's Exhibits 6, 7, 8, 9, and 10.
Go ahead.
If possible, we'd like to go one by one, so 6, 7.
That's fine. That makes perfect sense.
We'll see what that is.
Yes.
Okay.
Officer Cochran, what is depicted in Exhibit 6?
This photo depicts the driveway area of the property along the Pawnee Drive side. It would show that there's multiple vehicles of different sizes and types parked in the driveway, along with several items stored near the sidewalk adjacent to the property.
What?
Thank you. Is there Anything to note in terms of signage that shows the intention of the 290 Pawnee residents?
On the items stored near the sidewalk under what appears to be a blue tarp, there is what appears to be a handwritten sign on a piece of cardboard that says "free" on it.
Thank you. Can we move to Exhibit 7, please?
Why don't we, if you're going to move to admit, why don't you do it after each one so that we can take them up individually?
If that's the case, then we'd like to move to admit Exhibit 6 into evidence, Your Honor.
Any objection to the admission of Exhibit 6, Ms. LeCompte?
No,
Exhibit,
If this was after the hearings we already watched, because they already said stuff came back. I never seen this before.
6 will be admitted.
What is depicted in Exhibit 7?
This is a photo of a similar area. It is still the driveway of the property taken from approximately 10 to 15 feet north of where Exhibit 6 was taken. It shows that there are several pieces of loose property stored not only on the driveway of the property, but also in the bed of a truck that is parked on the driveway of the property.
Thank you. Your Honor, I'd like to move to admit Exhibit number 7 into evidence, please.
Ms. LeCompte, any objection to Exhibit 7?
no,
Exhibit 7 will be admitted.
Move to Exhibit 8, please. Also, Cochran, what is depicted in Exhibit 8?
Exhibit 8 is a photo of the north yard of the property near the northeast corner of the lot. In the photo, there is several storage containers of different kinds near the fence line of the property. There's some sort of stacked loose property on the right-hand side of the photo, and in the center of the photo, there is a vehicle which appears to be a Dodge Charger.
Out of curiosity, did you investigate this Dodge Charger a little bit closer to determine whether or not it was an operable vehicle?
I did investigate it slightly just from what I could see from the public right-of-way. In investigating it, I was able to observe that the front end of the vehicle was covered with a blue tarp, and the portion of the vehicle that I could see from underneath the tarp, it appeared that the front of the vehicle had suffered significant damage to the front end.
Now remember, yesterday we just looked at this picture from March. There was nothing back there. She's supposed to have been cleaning up, which we all know for the last year. Now from March to July, all of that stuff showed up. And you know, March, of course, obviously cold. Look at, like, you can't even see the house now. It's so much out there with the juniper bushes or whatever that y'all like joking about. This is not good.
Thank you. Can we move to, the people now like to move to admit Exhibit number 8 into evidence, please?
Ms. LeCompte, any objection to Exhibit 8?
only to the extent that I will be showing pictures that show that this is completely remediated.
Okay, Exhibit 8 will be admitted, and I'll consider other photographs of the area at a later time.
What is depicted in Exhibit number 9?
This Exhibit 9 is a photo taken from the rear patio of the adjacent property on Sioux Drive. It is taken facing west towards the property at 290 Pawnee. In it, you can see that there is loose property and accumulated items just on the other side of the fence line, which are visible from the adjacent property.
I'd like to move to Exhibit number 9 in evidence, please.
Any objection to Exhibit 9?
No, not at all.
Exhibit 9 will be admitted.
Yes, thank you. I'd like to move to Exhibit 10, please. What is depicted in Exhibit number 10?
Exhibit 10 is a photo taken from the parking lot of the United Methodist Church, which is directly north of the property at 290 Pawnee Drive. It shows 2 trailers with various items stored on the trailers. which have been parked across several parking spots in the parking lot.
I'd like to move to admit exhibit 10 as evidence, please.
Mr. Compton, any objection to exhibit 10?
To the extent that Mr. Laauo also will attest to the fact that he has permission to park those things temporarily at the Methodist Church. He's discussed that with the pastor.
All right, exhibit 10 will be admitted.
From your visual acknowledgement, does it appear that any new items were added between July 3rd, 2025, the date of the original trial, and today, and July 31st, 2025?
Yes, from what I could tell, the driveway area appeared to be mostly similar items that had been there at the beginning of July. But the north yard of the property where the Dodge Charger and the storage containers were at, the vehicle itself was newly added, and the storage containers that were near the fence line were also newly added.
Between the July 3rd, 2025 trial date and today, have you received any official complaints or investigation requests to the code enforcement agency about the 290 Pawnee address?
Yes, we have.
What did these complaints pertain to?
The requests that we had received were regarding the state of the property at 290 Pawnee Drive. And they had stated that after the property had been somewhat cleaned up in the past, items were now being added to the property, and that there did not appear to be any visible cleanup efforts ongoing.
When was the most recent complaint?
To my knowledge, the most recent complaint was received this past Monday, which I believe would be August 4th.
Did the complaint attach any evidence supporting their complaint?
I believe at least one of them included photo evidence of what they alleged in their complaint.
And did you review this photo evidence?
I did.
Did these photos depict a similar representation of the 290 Pawnee address to what you saw on July 31st, 2025?
Yes, it appeared that most of the items were in the same location that they were when I
I
inspected.
object to this because this has not been submitted in evidence. The photographs taken by the alleged complainant have not been submitted in evidence. And therefore, I have no ability to attest to whether those are accurate or not.
Mr. Altenberg, do you want to respond to that?
Yes, Your Honor. First off, as noted previously, the rules of evidence don't apply here in terms of the admissibility of this, in terms of whether or not it's maybe hearsay or not, Your Honor. The purpose of the testimony by Officer Cochran is to determine whether or not the photos in question of the complaint that he received more or less shows the address of 290 Pawnee on August 4th, 2025, being similarly represented by the photos as shown as July 31st, showing that at least as of this Monday, the July 31st, 2025 photos were an accurate representation of what the property looked like.
I object because I cannot judge, I cannot legitimately make a distinction between something I haven't seen and something that Officer Cochran has presented and what I know to be there.
I'm going to overrule the objection, but it's not there's not a lot of information for the court to consider because the court doesn't have access to those photographs either. So it may not give much weight from me given what I am able to see and not see.
Since July 31st, 2025, did you visit the 290 Pawnee address?
Yes, I have.
When did you visit the 290 Pawnee address?
The most recent time that I was at the property was this morning.
And what did you see this morning?
I observed there to be items still stored on the driveway. The driveway area appeared to be in mostly the same condition. There were several vehicles and trailers parked in the street on Pawnee and also on Sioux Drive. I observed that there were some items which had been moved around. I did observe that the Dodge Charger was no longer on the property. And I did observe that Mr. Laauo was actively performing some kind of activity in the rear yard of the property and also in the north yard of the property.
Were any of these items stored on the United Methodist Church parking lot?
Yes, there were items stored in the parking lot.
How do you know that these items were owned by the residents of 290 Pawnee?
Based on previous interactions and previous observations of the tenants of 290 Pawnee, interacting with the vehicle that was stored in the parking lot at the United Methodist Church. I knew that to belong to one of the residents of 290 Pawnee, and some of the items that were stored near the back of the vehicle were similar to those that were stored in the driveway area of 290 Pawnee when I inspected it last week.
Did you speak to anyone at the church about the storage of items on their property?
I did.
Who did you speak to?
I spoke to he identified himself as the facility manager for the church.
And this person's name was?
I believe Kyle Perez. I could be wrong, but I believe that was his name.
What did the facility manager of the United Methodist Church tell you about items being stored on the property?
I inquired with the manager about if permission had been granted to anyone from 290 Pawnee to store items in their parking lot. He had stated that it was a near daily occurrence that vehicles or trailers of different kinds would be brought onto the church's parking lot near the intersection of Pawnee and Sioux, and that it was almost a daily occurrence that he would have to make contact with one of the residents of 290 Pawnee to have the vehicles removed.
Objection. I'm objecting because there are many other people who temporarily bring a trailer or a vehicle or other kinds of equipment and leave them at the church parking lot. This is a regular occurrence. My bedroom is right across the street from that parking lot. And so to say that all of that was attributed to Mr. Laauo and to 290 Pawnee is, I believe, not accurate.
I'm going to overrule the objection, but I'm going to make it clear to the parties. The prosecutor is going to have to establish to the court's satisfaction that this is actually property that belongs to you or for your address. So all I've heard so far is that he sees property there that gets moved there. I haven't heard it tied up to necessarily be to your address.
Thank you.
Your Honor, to respond, I believe Officer Cochran has already testified to the property being on the United Methodist Church property from his own personal recollection, being from the 290 Pawnee address based off of what he's seen before of the property there versus what he's already seen on the address.
Both sides will get a chance to argue what's being established in the hearing.
Just to confirm previously the question, Officer Cochran. So the facility manager of the United Methodist Church did expressly tell you that the property that he requested on a daily basis to be removed was that of 290 Pawnee?
Yes, he stated that he had spoken with a resident of 290 Pawnee about specific vehicles and trailers, and that the items were removed by that resident after he had been asked, or after the request had been made.
And how often were these requests made by the facility manager?
He said that they were on a very frequent basis. At one point, I believe he said that they were happening almost daily.
And what is his stance about items being stored on the property?
From our conversation, his opinion of it was that they would like it so that there would be, or at least he personally, so that the vehicles and trailers were not being stored on the parking lot of the United Methodist Church.
Do you believe that these items, when they're moved off the property of 290 Pawnee and onto the United Methodist Church property, are being removed permanently from the 290 Pawnee address?
Personally, no, I don't believe that.
That's a personal opinion.
That's permitted.
You made a comment, Mr. Almer. Do you think it's permitted? Do you want to make a legal argument on that basis?
Yes, Your Honor. Officer Cochran is basing his opinion based off his personal knowledge of the situation. As someone who I will, if I may, actually, Your Honor, may I ask one further question before stating this?
Yes.
Officer Cochran, in your career, how many times would you have estimated that you've visited the 290 Pawnee address in your professional capacity?
Myself, I would say that I've been there, whether posting a notice or taking photos of some kind or another. I would say that I've visited the property at least 15 to 20 times, somewhere in that range at minimum.
Dang.
Your Honor, we believe that based off of Officer Cochran's testimony of being at the property upwards of 20 times in his professional capacity, that he has enough personal knowledge about the items that he's seen around the property, especially because he has been taking photos, are posting notices about these items in question to testify to whether or not items have been moved from a storage compartment on the United Methodist Church property / trailers on the streets back onto the property or vice versa.
So I'm going to I'll consider the testimony he's given, the factual testimony he's given. The property has moved back and forth between and he recognizes that some of that property that was on the 290 Pawnee address went on the church parking lot and then was removed from the church parking lot and then back onto the church parking lot. That factual testimony the court can consider. I'm not going to consider his opinion as to whether he believes it's permanent at this point.
So she been playing Legos basically, or Tetris, just moving stuff around to make it fit.
Officer Cochran, how many other code enforcement officers do you know have visited the 290 Pawnee address in their professional capacity?
I myself have visited with several other officers, mostly in the capacity of training while I've been the training officer for the code enforcement unit. But prior to myself being employed with the city, I know that there had been at minimum 3 other officers who had either investigated the property or taken some level of enforcement action there in the past.
Why do you use other code enforcement officers to the 290 Pawnee address to train them?
We believe, or at least I believe, that it's a property where there's been continued efforts for compliance within city code, and it's a property that has required a level beyond what is normally required to gain compliance. Typically, it's something that we can resolve relatively quickly. But this is 290 Pawnee is a property that we've had to visit for several years in a row to try to have the violations at the property complied.
And have you seen compliance from the visits?
From previous cases, there have been moments or some short periods of time where the property does appear to be in compliance in some capacity or another. But based on recent inspections at the property, it appears that items will return to the property and violations continue to reoccur there.
Thank you, Officer Cochran. No more further questions.
All right, Mr. Comte, any questions for Officer Cochran?
I think I've covered most of my questions with respect to the objections that I have made, Your Honor.
Okay. Officer, you can step down. Thank you. Next witness for the people.
Yes, Your Honor. The next witness we'd like to call is Mr. Jason Strauss, who's appearing via Zoom. I just informed him that he should be available to be spoken to.
All right, Mr. Strauss, if you'll unmute your microphone and enable your video, and then I'll swear you in. And good afternoon, sir.
Hi, good afternoon.
If you'll raise your right hand for me, Mr. Strauss. You swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you, sir. Go ahead, Mr. Altenberg.
Hello, Mr. Strauss. Can you please state your name and spell your last name for the record, please?
Jason Strauss, Strauss.
What is your address, Mr. Strauss?
4630 Sioux Drive, Boulder.
And what is the address that abuts the side of your property?
290 Pawnee.
Mr. Strauss, how long have you lived at this address in Sioux Drive?
I just passed our 2-year anniversary of buying the house.
And throughout this past year, have you seen loose property being moved to and from the 290 Pawnee address?
Yes, constantly.
Do you believe that the residents of 290 Pawnee had the ability to move large items to and from their property throughout this entire period?
Yes,
And throughout this entire period, you've seen this movement occur?
yes. I think I mentioned my earlier testimony, a forklift on the property, moving large industrial items off the property onto trailers around the property.
Wow.
Have you had any interactions with the residents of 290 Pawnee between the date of July 3rd, 2025 and today?
Yes, I have.
And how would you describe these interactions?
Mr. Laauo came over recently again to apologize for the state of the yard He expressed his complaint that, it seems he was accepting responsibility for a lot of the loose property, but he is not the defendant in this case. Again, he apologized and requested our assistance, essentially asked us not to come here today.
Oh.
Yeah.
Well,
To gain further information from your testimony, what do you mean by he asked you to not come here today?
I think I mentioned in the past that we all would have liked to resolve this in a neighborly and an amicable way. I think we all regret that we're here in court today. He came over, asked us to, like I said, not testify. We had heard from several neighbors in the past that they were unwilling to testify because of the residents of 290 Pawnee's kind of threats to sue them, essentially. And Mr. Laauo mentioned similar things towards us.
oh.
So.
Mm.
You also mentioned that other neighbors are afraid to testify. To your knowledge, what is the opinion of the 290 Pawnee address by the neighborhood? Or at least by the neighborhood that you know, the neighbors that you speak to?
Yeah. I think I understood that the testimony of 11 neighbors isn't admissible, but I think the fact that there are 11 neighbors who are willing to put their names out there, and I personally know of more who are not willing to put their names out there, shows that the residents don't even fully understand the scope of the trouble this is causing us and the neighborhood. So did I answer the question? My mind is.
I appreciate that answer. Thank you. Now, from your experience, you said you've been living here for 2 years now. How long would you say that, how many times would you say that the residents of 290 Pawnee have exclaimed to you that they were intending to clean up the alleged violation?
Several, easily half a dozen. They often give us a date. Oh, we'll have it done by this time. We'll have it done by that time, including by the trial date. And I've seen really big movements on certain days. Like I mentioned in the past, when my son was born, they had some help and they were able to clear out almost entire front yard in a day or two. But again, not only was there very little movement, or there's been some progress since the trial, but this car has come and gone. And the fact that it's gone today, doesn't excuse the fact that there's a trailer of a broken down car being moved. And by the way, it's on the property. It's not in the driveway, so it's going up and down the sidewalk where my son bikes. So yes, we've heard several attempts to clean up, which we appreciate. But I don't think they're aware of the scope of their own problem.
And as a result of this, what would you like to see happen as a result of this hearing when addressing the 290 Pawnee address?
I think it's fairly simple to have it cleaned and to not have junk appear again. I'd further add, and I don't know what's possible here, but again, the movement, like the fact that this broken down car isn't here today, but it was moved on and off. It's been moved around, and there's a constant movement. So simply looking, and I know, having spoken to several neighbors also, it's very simple to have the junk removed, not to have it accumulate again, and not to continue have this shuffle. I see the church window outside my parking lot. I can also attest to the trailers being brought full of property from 290 Pawnee, constantly being moved back and forth. But yeah, simply put, to have it cleaned up.
And is there anything else you'd like us to know that relates to the 290 Pawnee address and or the defendant, Ms. LeCompte, pertaining to the violations?
I don't think so.
No more further questions, Your Honor.
Okay. Ms. LeCompte, any questions for Mr. Strauss?
Mr. Strauss, I'm sorry you're here. I'm very sorry that I'm here as well, but I need to ask you a few questions. You just testified that your little boy has trouble riding his bicycle on the sidewalk near my house. And can you please describe what sorts of obstacles that you say are in his way or what kinds of dangers he encounters?
Yeah. I won't, there's not anything over onto the sidewalk, but there is quite a constant movement of things. We're surrounded on the street by a trailer, which is not, well, several trailers as of a few hours ago with loose items. When I say loose, I mean on a trailer, not tied down. So, yes, there's nothing obstructing, but as my 2.5-year-old bikes by, I am fairly vigilant as to what's happening. So,
Okay, but there's nothing really that is impeding his way or falling upon him or anything like that, or sticking out to bother him.
that's correct. Yes. And
If there were, I would be very sorry. So
thank you. No, yes. He enjoys your sunflowers very much.
thank you.
Yeah.
They have been a bone of contention, as you well know. People don't like them. But
I haven't even seen those.
you're welcome to come and get some.
Thank you.
No more questions.
Okay. Any redirect, Mr. Almer?
Yes, one quick question, Mr. Strauss. You said that nothing is actively bothering or impeding your son's ability to ride his bike, correct?
Correct. There's nothing on the sidewalk.
But from your personal perspective, it appears that the property storage on or around 290 Pawnee poses a threat for it possibly happening?
I believe so. I mean, the scope and the breadth of what's on the property is, loose junk essentially. So I believe so, but again, there's nothing specifically on the sidewalk, but there is a lot of loose property nearby.
No more further questions.
Okay. Mr. Strauss, you are free to unmute or mute your microphone and your video. Do we anticipate calling Mr. Strauss, either party recalling him, or can we relieve him from this meeting?
No, Your Honor.
No.
All right, Mr. Strauss, you're free to leave the meeting, and you're welcome to watch if you choose to, but you're not required to stay.
Thank you.
All right, thank you. Any other witnesses or evidence for the people?
No, Your Honor.
All right, the people have rested their case. Ms. LeCompte, it's now your opportunity to put on evidence if you choose to do so. You have the option of testifying. You're not required to do so. You have a constitutional right to remain silent. If you choose to exercise that, you can. You can also call witnesses to testify besides yourself. How would you like to proceed?
I'd like to proceed as a witness so that I can be sworn in this court of law.
Okay.
Because my own integrity has been impugned in this.
Okay.
I'd like to proceed under oath.
Okay, that's fine with the court. Let me make sure that you understand you can't be compelled or forced to testify. When you testify, you'll be subject to cross-examination. That means Mr. Altenberg can ask you questions. Do you understand that?
Yes.
If you've been convicted of a felony, he could disclose that felony conviction to me. If I were to consider a felony conviction, I would only consider it as it bears upon your credibility as a witness. Do you understand that?
Yes, I do.
You're making that decision to testify voluntarily today?
Yes.
Is anybody forcing you to do that?
No.
I will find it's a free and voluntary decision to testify. If you'll come forward, I'll have you sit and you can bring whatever documentation you want so that you can keep track of what you'd like to say, and we'll just have you come up and I'll swear you in. And if you'll raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you, Ms. LeCompte. Go ahead and have a seat. And then you can tell me what you'd like me to consider. If there are exhibits that you would like to introduce, please identify them by the letter that you want me to consider, and we'll pull them up, and then you can tell me what they are, and we'll determine whether or not they're admissible.
Okay, I would like to submit some photographs as evidence, but I didn't number them as subsequent to the court's numbering order.
So we gave them letters. The prosecution has numbers and the defense has letters. And what Ms. Mahoney mentioned to me before we came on this afternoon was that she had separated those, is that correct?
We do. From the first emails that at least we received, and as clerks, I have it starting from Exhibit A and it goes through Exhibit M from the ones that Ms. LeCompte sent to our B desk around 2:00.
And which are the ones that were submitted at the trial? Or
None of them, as far as I
so
know,
we
I
have
uploaded.
A through M are most recent.
That's correct, and I
Okay.
do have them specifically labeled as such as like for today's sentencing,
Okay, so we'll just pull up Exhibit A, and if you'd like to take a look at that and determine if you want the court to consider it, that's how we could do it, is to show you what Exhibit A is.
Okay,
You
Your Honor,
sent,
there is
you
one-
sent one document with a bunch of photographs, and we separated them out so that each photograph could be identified separately and admitted separately.
There is additionally, Your Honor, a photograph of the backyard, looking from the north, that I submitted previously in the previous trial. I don't know what number that is, and I'd like to have that brought up, if that's possible.
So I'll ask Sabrina to look through those on her own while you're testifying, if she's able to do so. And then she can perhaps give us a hint as to which one she thinks it might be, would be of the backyard that was submitted by you during the trial, correct?
Okay, and we could look at the ones that I submitted early this morning.
Which one do you want to see first?
I
The
guess,
way it was previously?
no, the way it is right now.
Okay. So let's start with.
No, I'm sorry. The ones that I submitted, the ones that I submitted early this morning are ones that have not been shown in trial before.
That's right.
And they are basically pictures of the front side and backyard that were taken in the last 3 years by me.
So which one do you want to have Sabrina pull up first?
Well, let's look at Exhibit A and I can see what it is.
Okay.
Okay, this picture
Huh?
is just a picture of the front yard taken in June 21st, 2021.
Okay.
And can you show me then the next 3 pictures?
I'm sorry, June 21st of 2021?
No, yes,
So some time ago.
yes.
Okay.
I'm introducing these, Your Honor, because I respectfully would like to submit that for most of the 34 years I've lived in that property, the yards have been beautifully kept and certainly in keeping with the neighborhood. And so I have just a few pictures that kind of demonstrate both the longevity of the kemptness of the neighborhood, of the yard,
Okay,
okay? And
Exhibit
also
A, that's Exhibit
my
A.
wildflower garden.
Okay, any objection to Exhibit A, Mr.
Um,
Albert?
Yes, Your Honor. Obviously, the evidence is quite low. We think that this is not relevant.
No.
Because of the
Let him
amount of
finish.
time it's passed between then and now, it has no relationship to how the property's been upkept, even over the course of the past 2 years.
I'm sorry, I disagree.
I'm going to allow Exhibit A. I may not give it a lot of weight, but I certainly will allow the defendant the opportunity to provide some background as to how the property was kept prior to the ongoing litigation that's going on now. So Exhibit A will be admitted. It may not get a lot of weight, but it'll be admitted.
And then there are some other
You
pictures.
can introduce those, and again, I'll let them be admissible if you lay a proper foundation as to what they represent. So this is Exhibit B.
This is basically right near the front door. These are native wildflowers, and it's part of my attempt to xeriscape and to provide a garden for pollinators and something pretty for the neighbors to look at. Next slide, please.
It feel like we just went from a house with junk to a greenhouse.
Objection to admission of Exhibit B.
We're going to reiterate this similar objection, Your Honor.
All right, and Exhibit B will be admitted. I don't know what weight I'll give it to it, but Exhibit B will be admitted.
This is a picture of the front yard and the front sidewalk. There's the flagstone sidewalk, shown for the same reason.
This is Exhibit C.
Yes, this is very similar to what it looked like this spring.
Any objection to Exhibit C?
Yes, Your Honor, the similar objection.
The relevance objection will be overruled. Exhibit C will be admitted. You can continue on with the next exhibit. This is Exhibit D.
This actually was taken this year. And it again is a different view of the front yard and the front doorway.
Approximately when was that taken, do you know?
June 21st, I sent them out.
Any objection to Exhibit D?
No, Your Honor.
Exhibit D will be admitted. This is Exhibit E.
This is similar. This is also taken June 21st, 2025.
Any objection to Exhibit E?
No, Your Honor.
Exhibit E will be admitted. We can go on to the next exhibit. This will be Exhibit F.
This was taken in about 3 weeks earlier. It's a side yard on the north side, taken in 2021 by me, 2025, I'm sorry. And it shows the mitigation with the side yard clean and the flower beds being restored with native plants.
Any objection to Exhibit E?
Just to specify, when was the date and time of this photo taken?
This would be right at the beginning of June, 2025.
In June, okay. No, Your Honor.
Exhibit F will be admitted. We can go on to the next exhibit, which will be Exhibit G.
This was taken in late April 2025, and it shows, late April 2024, which shows my beginnings of planting a vegetable garden. And then on the backside, in the south end of the backyard, it shows that there's no garbage there, no trash.
This is April of 2024.
Yes, a year ago, I had someone to help me at that time because I had a serious shoulder injury and I couldn't do the work myself.
And this is in the backyard.
This is the backyard.
Any objection to Exhibit G?
It also shows the back of the garage.
Yes, Your Honor. We're going to raise our relevancy objection also for the purposes of the evidentiary barriers. I assume unfairly prejudicial is applicable here.
Not sure what weight I'd give to that objection.
Okay, to me, these pictures were before the last set of pictures that was admitted. I don't understand why he's looking at these pictures and letting her admit these, because that's old. And all she's showing is pictures of flowers and she's not doing the overall property. Like, it doesn't make any sense now.
We would nevertheless raise the objection of being unfairly prejudicial, as Ms. LeCompte has claimed that this photo shows that there's no trash, which may be true based off the photo, but the emphasis of the word / the justification she's using here is to try to describe the area as a whole rather than what just is seen in the photo.
Exhibit G will be admitted. It obviously only shows a very small portion of the backyard, but in the court's view, both sides are going to make argument with respect to the longevity of the problems at 290 Pawnee. That allows Ms. LeCompte to show that at least at some point in time, there may not have been as significant problems at the property, or at least portions of the property. But Exhibit G will be admitted for the limited purpose of what it shows in particular in that area of the property. You can continue. Let's go to Exhibit H.
Okay, can you scroll down just a little bit? This picture is the immediate back, it's in the backyard, it's right off the back patio, outside, just going outside the kitchen door. And it, again, is, this one actually is this year, in late April.
Of 2025?
Till 2025, late April, early June. And it shows the other garden, which is an herb garden, and the tomato plants that I have on the back patio, which are it's the only thing I could actually do gardening wise this year. But again, this is to demonstrate that this has not been what has been characterized as a junkyard and a landfill.
Any objection to Exhibit H?
Based off of my understanding of the evidentiary barrier for this hearing, no.
Okay, Exhibit H will be admitted.
Wait a minute, is this a drone shot of her house? Has it been scaled down? Because she said it's not a landfill. So I'm thinking, where's the house at? Maybe all of those little bushes is covering it. I don't know. Oh,
This is Exhibit I.
This exhibit was taken this morning, and it shows the easement on the south side of the street. It is parallel. It's the exact same elevation as Officer Cochran's photograph that he showed in of his exhibit. What is it? This is the condition of his exhibit 6 now. All of the items have been removed, and it shows the removal also of extra vegetation and weeds, and the improvement of that as of this morning.
Any objection to Exhibit I?
Yes, Your Honor. We understand that the differences in the burden for submitting evidence is different between pro se and the city's attorney's office. But we do not believe that it should be admitted, since this photo was taken this morning. It was after the photos that we produced to Ms. LeCompte had been provided to her. She had 4 or 5 days after providing our photos to take this and provide it to the court earlier today. We believe it's unfairly prejudicial and is a complete reaction to the photos we've already provided to the court as evidence.
I'm going to allow Exhibit I. You can certainly cross-examine her if you choose to about the process that has occurred in submitting photographs to her and then her response with Exhibit I.
This is in response to exhibit number 7 by the prosecutor, and this showed picture showed pallets and some stacked materials and things like that, and that has been removed and is removed permanently.
the tires doesn't even have air in them. Like, how did they even get that up there after we saw the other pictures? Well, he mentioned a forklift. Maybe they used the forklift to lift up the truck. This is crazy.
By the way, the materials that were displayed in the previous photograph that I show also have been removed permanently.
Any objection to Exhibit J?
We'll reiterate the original. We can cross-examination.
Exhibit J will be admitted. Certainly will allow cross-examination about the contents of Exhibit J.
This is in response to the Exhibit 9.
This is Exhibit K, just for the record.
Okay, thank you. This is taken from the Strauss's backyard, and it is the same elevation that was taken by Officer Cochran on July 31st, I believe. And you will see that through the fence, you can see that a great deal of the materials have been removed, and from the north side of the yard. The photograph I'm asking to have pulled up from the previous records will show the south side of the yard remediated as well.
I think perhaps I found that, so just let me know when that's ready for you.
This is not the same view that we saw when the code enforcement officer went to take that picture where you see all that junk out there in there. Why would you take a picture in front of the tree when you can't see the house?
Okay, good. We'll talk about Exhibit K here first. So Exhibit K is a photograph, and you said that's your backyard or your?
Over the fence is my backyard.
This is taken from Mr. Strauss's property?
This is taken from the Strauss backyard, and it is the same elevation as the one that Mr. Cochran showed earlier.
So the sidewalk that we see is actually Mr. Strauss's
That is
sidewalk?
there's that sidewalk.
And the brown house behind that is your residence?
That's correct.
Okay. Any objection to Exhibit K?
No, Your Honor.
Exhibit K will be admitted.
Mr.
Now,
Strauss
Sabrina,
needs
you
to do
can
that.
let Ms. LeCompte know that you found the exhibit from the trial that you think is relevant, and you can go ahead and pull that up and identify what exhibit letter or number that was.
Okay, I think, and I could be wrong, so please correct it, but I think you had been before referring to Defense Exhibit F from before, which I'm pulling up now.
So this would have been admitted in the trial. This is Defendant's Exhibit F from that trial.
Is that correct?
That's right.
Is that the one that you wanted the court to consider?
Yes, I do have one more exhibit, but this is the one that comes from the.
Okay, why don't you go ahead and tell us what you'd like us to know about Exhibit F?
This Exhibit F shows that what had previously been displayed at the trial of a great deal of debris and junk and stuff piled right in this photograph is gone. And has been gone since before that trial on July 3rd.
All right, so what you're saying is what we're seeing on July 3rd has not changed as of today's date?
That's correct.
Okay. And of course, the way we've labeled these, we may need to, we'll call it F, we may have to go back and label those exhibits that were letters for Ms. LeCompte as F-trial. So all of those, that way it's very clear that the sentencing exhibits that have been now admitted are different than the trial exhibits that were admitted.
Thank
That
you,
makes
Judge.
sense
I'm
to
very
me.
sorry about the confusion.
All right, you're an unrepresented litigant, so we do our best to try to make sure things get taken care of. You can continue, so I think the next would be Exhibit L that has been submitted by the defendant for this sentencing hearing. I believe that's Exhibit L.
Yes. This is a picture of the the north side yard. It is where right where the unpainted fence is, was where the blue barrels and other things that Officer Cochran highlighted, where the Dodge Charger was parked, and there we go. The dirty area, the bare area is where the plastic slabs were, and they're all gone. They've been removed.
And when was Exhibit L taken? When was that?
This was taken this morning. The materials, some of them were removed earlier this week.
And that's the front area of the house that basically looks over towards the church.
The north side looks towards, it faces the church parking lot.
Got it. Any objection to Exhibit L, Mr. Ulmer? Exhibit L will be admitted. Do we have any others, or is that, I think that might be
There's
it.
M.
There's an M?
M. Sorry,
Should be
apologies.
more.
Exhibit M.
All right, so Officer Cochran testified that, I forgot how many times, many times, he has appeared in his professional capacity to talk with the neighbors and, in fact, to take photographs, specifically to take photographs. This picture was taken on the same day that Officer Cochran took many of the photographs that he's showing here. I believe it was taken on the 31st of July, and it shows Officer Cochran not dressed professionally, not wearing a badge, not having anything that would identify him as a code enforcement officer. And I'm submitting this to suggest simply that this is just before he took the picture looking into my backyard or looking over my fence. And what I'm suggesting is that this would be misleading up to people who were observing it, because he does not look like an officer of the Code Enforcement Department.
Objection to Exhibit M.
Yes, Your Honor, we don't believe that this is a correct representation of what Ms. LeCompte is trying to claim that it is. She was unable to identify the person in that photo from the
It's
back.
Officer Cochran, and Mr. Laauo, who took this picture, will attest to having witnessed specifically this event.
No objections, Your Honor.
Well, I'm not going to admit Exhibit M. It's not relevant to the court as to whether Officer Cochran was wearing a badge or whether he was looking over the fence. So Exhibit M will not be admitted.
Well, good, Judge, because anyway, Mr. Laauo is not a law enforcement officer. So why is she trying to ask him? Say, well, he can tell the same story too. They both lying.
Okay. Now, we've got the exhibits that are admitted. What additional testimony that would you like to offer to us, Ms. LeCompte?
I have a kind of statement, if that would be all right.
If it's based on facts, you can provide facts. If you're wanting to tell me, make some argument about what sentencing should occur,
No.
that can be at the end of the hearing. So if you want to offer some specific facts in the statement, you can go ahead and read from it. It's something that you've prepared.
Okay. I want to talk about my feelings about the condition of the property and also the history that led up to it, which I think is germane.
Some of it might be relevant, some of it may not, but we'll see if there's an objection.
Okay. When I realized that the cleanup has not been completed to my satisfaction, but the front and the side yards are done. The backyard is about half done, and the easements on both sides of the driveway are cleaned up. When I bought the property at 290 Pond Eve 34 years ago, it had been a poorly cared for rental for many years. I'm a gardener and I worked really hard to improve the yard. I specialized in growing native plants and flowers, and for most of the 34 years I've lived there, the entire property has been well kept and beautiful. That's why I submitted the pictures that I've just shown. With the exception of the last few years, I've always been, I think, a good and helpful neighbor. So the story I'm going to tell you now is not to ask for sympathy, but just to explain why the party became so offensive and depressing to my neighbors. And I also want to explain that none of the loose items and junk in the yard are mine. Not all of them belong to my longtime partner, Mike Laauo. I have absolutely no attachment to or use for any of them. Nothing would make me happier than to have them disappear forever.
What?
I also want to explain that Mr. Laauo has been a gifted professional, a successful entrepreneur, and a devoted single father to his 2 children who have been part of my life since 2007. He's always been willing to help.
Altenberg, you got an objection?
Yes, Your Honor, we're objecting on relevancy purposes. Not only does the claims about who the items are owned by not relevant to this matter, saying Ms. LeCompte is arguing found guilty of the alleged violation, but also describing a witness or an individual who, based off her disclosure, she intends to call as a witness, and speaking about his character is improper character evidence as well.
I'm going to sustain the objection just from a relevance perspective. I know you may want me to have this type of information. It's not relevant to the determination I have to make. I'll allow you in closing argument to certainly articulate a few things that you want the court to consider. You've laid some foundation for talking about the property and its history, but I don't want to, at this stage, because you're really just offering factual testimony, I'm not going to allow you to offer those types of facts. The issue for me is the state of the property, how long the property's been in this condition, and what the state is currently. And when I say how long, I mean since the initiation of this case. So I'm not going to be going back 5 and 10 or 15 years to discuss what it was.
I'm not going, the next part of my story, I think, is germane.
Well, let's try and see. I'm sustaining the objection on the other part, but you can continue.
One of the problems I face is that Mr. Laauo, whose property this is, suffers from, whose items these are contention, suffers from a hoarding disorder that has led to the condition of my yard.
What?
Contributing to that has been, would you please
objection?
let
Go
me
ahead,
finish
Mr.
the
Altenberg.
sentence?
Go ahead, Mr. Altenberg, you can object.
Yes, Your Honor, we'd like to object for relevancy purposes. Once more, she's trying to testify to the character of someone else that she intends to call as a witness and uses a justification for something that she's arguing found guilty of.
I'm going to sustain the objection. Mr. Lau's physical and mental state is not relevant to the state of the property or the sentencing with respect to you, who is responsible for the property. So objection sustained.
Oh my.
Your Honor, I accept that I am the owner of the property and responsible, but also I would like, there are some extenuating circumstances that are related to all of this, and I would like to be able to explain those.
I'll allow you briefly in closing argument to articulate what you think the appropriate sentence should be given the circumstances that are personally facing you. So you can give me a little bit about that, but I really don't want to go into a lengthy detail about one person who is not even the responsible party's physical or mental disabilities.
Well, it's even the fact that she's saying that now, after all these hearings, She's saying she was trying to get her items off the property and justify why certain things should be on the property. Now all of a sudden it's all Mr. Laau's. I mean, that sounds like a contempt right there, huh?
Then I will have to say simply that I don't know quite how to, I don't know how to disentangle what I need to say without running afoul of yours and the prosecutor's objections, Your Honor. I have been disabled for really pretty much of the last 3 years with injuries and surgery. And I have been completely dependent on Mr. Laauo. And I have been too ill to really notice how much was brought into the house because I rarely left it. I should have been aware perhaps of what was going on, but what is at fault here? Because I am the property owner, is my inability to curb Mr. Laau's hoarding behavior or to hold him to promises to stop bringing stuff to the house, and even his unwillingness to clean up in a timely fashion, even to getting photographs, the property prepared for photographs in time for court. That is what is relevant, and I would like to be able to speak about it just briefly.
I've heard you. You can continue. When you're focusing on your inability, is
Yes.
fine for the court.
My inability to do that has resulted in the accumulation of trash that has so disturbed the neighbors and myself. Some of the problem occurred during my extreme disability when he moved quite a few items into my backyard because homeless people were stealing his property from where they were stored. And I was really too ill to notice how much was being brought. Mr. Laau's hoarding disorder has worsened over time. And though I'm slowly regaining my strength and mobility, I am now faced with what I couldn't handle when I was so disabled and dependent upon him. And that is that he will have to cease using my property as a work and storage space and complete the cleanup on it or leave. I have told him that he must comply with my decision, and also that if his property is not removed, never to return again, I will hire trash haulers to remove it and dispose of it. This has been a very difficult time for me. I know that this ultimatum could result in his departure. I do not know what avenue he will take in this. I admit to having some fear and apprehension about this decision. Again, I want to apologize for causing such distress to my neighbors because because the letters that they sent have been ruled inadmissible. I can't comment on the overstatements that were made and that are influencing the prosecutor in his arguments. I can't comment on the degree of overstatement and misleading comments there.
Let's pause.
However,
Mr. Altenberg standing. Mr. Altenberg?
Yes, Your Honor. You've already ruled that Exhibit 11 is inadmissible. Ms. LeCompte is commenting on her inability to comment on the overstatements. She is therefore commenting on the statements that she's already seen and is staying on the record.
Since they're not admissible and I'm not considering it, a comment about something that I haven't considered, and it is not any specific comment. I can't really find a reason to sustain an objection. She hasn't made any statements about what's in those letters. So I would ask you though, Ms. LeCompte, there's no point in talking about them because although Mr. Altenberg may have seen them and considered them, I have not, and I will not.
So I've told you just now of my plans for remediation. And what I will do,
I'm not sure I heard you say, what is your specific plan for remediation?
I have told, I have so far been unwilling to call in trash haulers to simply remove everything because it's Mr. Laau's property, because I've lived with him for 17 years, and because this would cause our relationship to be destroyed. However, I have, as I have just said, made an ultimatum to him that he must completely clean up the property in good order.
And did you specifically say a date certain for that?
I did not say the date certain. He must confront and control his inability to stop hoarding and leaving things at the property. He has to find another place to do his work and his storage. And if it's not, that doesn't happen, I will hire trash haulers to remove and dispose of it. And I know that this will probably result in his departure and the rupture of our relationship. And I don't know what he's going to do. And I admit being somewhat fearful about this. Those are my plans for remediation.
Okay.
And again,
What's it, Mr. Altenberg staying? Mr. Altenberg?
Yes, Your Honor, I'd like to object for relevancy purposes. Ms. LeCompte is testifying to what she believes sentencing would apply for Mr. Laauo in this situation. She's testifying to all the actions that Mr. Laauo will be taking and testifying as if should apply to sentencing to her.
I'm going to overrule that. I think she's talking about what her plan is, and I've accepted that. It'll be up to me to decide what the sentencing will be, but certainly what plans a defendant has to remediate a problem is relevant in sentencing.
That attorney might as well not stand up. Because I guess he stands up and doesn't say anything because he hesitates on his objections, and then it's a 50-50 chance every time.
You can continue.
Your Honor, I have two options. Either hire trash haulers right now to move everything away, or rely on Mr. Laauo to do this expeditiously, because I personally am not able to physically do that work. And that is why I am, yes, responsible, but what I am taking responsibility for is to force him to do what he should have been doing
Oh my goodness.
and creating a hammer to make that happen.
Just sentence her. Be done with it.
I guess that my closing will be what I plan to say next.
Okay. Any cross-examination? Mr. Altenberg?
Yes, Ms. LeCompte, you testified on July 3rd, 2025 when addressing the allegations of non-compliance.
On what date?
July 3rd, 2025, it was the trial date.
It's possible, just a moment. I need to
No.
check something with my clerk.
No, the trial date was July 3rd.
That's what I said. So July 3rd?
No, I thought you said July 23rd. All right, let us go back to your original question.
I'm waiting until the.
You can continue now. I need to just clarify my availability for the court to go beyond the 5 o'clock hour because we're getting close to that.
Thank you. On July 3rd, 2025, when you had this trial, how did you plead?
I pled not guilty.
And can we
Wait a minute,
bring up exhibit?
I am now getting terribly confused. I pled not guilty to the charges that are in 1045.
Can we show the defense's exhibit D-trial, please?
Not the correct one.
Yes. According to your testimony on that date, this photo was taken on April 22nd, 2025. Do you remember what you testified to about this photo during that time?
I believe I testified that it showed that there was a lot of trash, there were old refrigerators, there were basically what has been characterized as loose items of trash filling the driveway and that they have been completely removed.
Thank you. Can we show the People's Exhibit 6, please?
From the trial, is that
Yeah,
correct? Or from the
People's
first?
Exhibit, People's Exhibit 6.
Okay,
Yes.
Mm-hmm.
is that the correct one?
Yes.
Okay.
Now, Ms. LeCompte, you testified to the allegations that on March 5th, 2025, the trash there was alleviated on April 22nd, 2025, correct?
Yes,
At that time, did you state that the issue was completely cleaned up, correct?
all of the material, the junk and materials, the refrigerator and all things like that have been removed and they've not been put back. The items that are just to the right of the mailbox in the photograph are items that were marked for free. And they had a sign on them that said, and you can see it just to the left of that white docket thing, saying that all of those items were set up for free. And so they were not taken away. And so recently we have taken them away because nobody seemed to want them. The items to the left of that are sitting on a slab, which are my trash cans, which were there in readiness for the garbage men to pick them up. The vehicles are vehicles that were temporarily put there. They will be removed. They belong to Mr. Laauo, and I'm not quite sure what his disposition is for them.
Nevertheless, would you say it appears that there is trash and disposables on the property on July 31st, 2025?
They are things we are trying to get disposed of by giving them away for free. That was not effective, and so we've taken care of that in other ways by getting rid of them. And as I showed the picture that I showed that was this morning, they are gone.
You testified today that, and I quote, they are gone, the front yard is done and the backyard is half done, correct?
Yes,
You testified to something similar about the April 22nd, 2025 photo, correct?
I can't remember which one that is.
The photo that we just showed you, the Exhibit D dash trial that pertained to the front yard?
Can bring that up.
She'll pull that back up for you.
That's this one.
There you go.
Yes, okay, what?
Did you testify to the issue being alleviated, correct?
The items that had been of issue were gone and they have not returned. There are trucks there, but that is not the same thing.
You today were privy to the testimony of both of the people's witnesses, and you heard the testimony of both Officer Cochran and Jason Strauss, who stated that items are constantly moved and returned back to this property, correct?
I heard them say that.
Now, are you, do you have a plan in mind to ensure that, for example, what occurs today in terms of what you've cleaned up will result in items not returning back to the property?
All I can tell you is I give you my word, and I give you also the fact that I don't like this either. And I also would remind you of the ultimatum I have given to Mr. Laauo with regard to moving his things. These are his things. And if you would like to impugn my integrity and giving you my word under oath, that is up to you. But all I can do is tell you I have done absolutely everything in my power and at some risk to myself to make this happen.
Can we move to Exhibit F dash trial, please? I believe Ms. LeCompte also utilized it today. This is the southern portion of your backyard, correct?
That's correct.
And you, during your testimony today, did you testify to whether or not this is an accurate, up-to-date photo of the property, correct?
Yes, the grass hasn't been cut, and there are many things that still need to be restored. The flower gardens really are in bad shape. But again, that's going to take me a little bit of time. But basically, the large pile of what was characterized by Mr. Reynolds, the prosecutor, as junk, which you did not see, but which was in a photograph taken over the fence, again, from the Strauss's backyard, showed that pile, and that is gone and it has not returned.
Can we show what is labeled, I believe, People's Exhibit 9, please? You just testified to the fact that the items in the backyard have been removed and they have not returned. What do you see in this photo?
I said that a good deal of them have been removed, and I did not say that all of them have been removed. And I also said that the north end of the property has not been fully, I admit, has not been fully remediated.
Can we now address, I believe it is,
And by the way, I also showed a photograph taken this morning that showed that the large black barrel, I think that is what it is gone.
thank you. Can we please pull up the defense's exhibit? I believe it is,
From today's hearing?
yes. For description purposes, because I know there's a lot of them. Can we move to actually I first, please?
No, it's the other one.
This is I believe, correct?
Yes,
Yeah.
I.
Thank you. You stated in your testimony today when you provided this evidence that this was in response to the People's Exhibit, correct?
I did, and I did not say that it fully responds to everything that might have been implied in People's Exhibit. I was using this to show the fact that loose items have been removed.
So as you noted, this is a response to the People's Exhibit. Did you prepare this exhibit as a response to the photos that we had already disclosed to you to be bringing in trial?
I did.
Can we please move to People's Exhibit, or not People's, Defense's Exhibit J, please? Similar questioning, you said this was in response to the People's Exhibit. Did you take this photo in preparation for today's hearing as a response to the photos that we provided to you in disclosure?
Mr. Laauo took this picture at my request, but it was taken this morning at my request.
And just to poke at what's in the photo, the vehicle there on the right, does that vehicle appear operable?
It has a flat tire, but I have not been able to drive it myself. I wouldn't drive it, so I can't answer that question.
Thank you. Can we move to the Defense's Exhibit K? And did you state today during your testimony that this was in response to the People's Exhibit 8 or 9? People's Exhibit 9?
Yes,
And this photo was taken when again?
I'm sorry, this morning, I
Thank you.
believe.
Your Honor, no more further questions.
Okay. Anything else from you, Ms. LeCompte?
No, sir.
All right, you can step down. Ms. LeCompte, do you anticipate calling any other witnesses?
I would like to call Mr. Laauo.
And how long do you think Mr. Lau's testimony will be?
I hope it will be brief.
Let me just turn
Oh, he ready to go home.
the party. It's 5:00. I'm not saying that we should stop now. I would prefer not to, and I can be here for a period of time. But let me just check with my clerk and see her ability.
I can stay. can we have a small break so we can use?
We'll take a break for 5 minutes, but how long can you stay?
I can stay as long as I need to.
Okay, so I'm anticipating that we want to wrap this up in 45 minutes if we're able to do so. Perhaps it'll be even sooner, but we'll stop at 5:45 one way or the other, and if we have to come back for additional testimony, we will. We'll take a 5-minute break, and then you can call Mr. Laauo to testify.
Thank you.
If I was Mr. Laauo, I wouldn't say anything because she threw him under the bus big time. Let's see what he gonna say though.
And we are back on the record. Let's call Mr. Laauo as a witness. Mr. Laauo, if you'll come forward.
There he
When
is.
you get to the witness area, if you'll raise your right hand, sir.
Thought his ankles was messed up.
Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, go ahead and have a seat if you will. Go ahead. Ms. LeCompte, questions that you have for Mr. Laauo?
Mr. Laauo, do you have a statement to make?
Yes, I do. May I start or?
Go ahead, and we'll see if there's an objection, but keep it relevant to what you've been in the courtroom so you understand what's pertinent to the court and what is not.
So I, of course, sorry, having a problem with the chair bouncing, or me jittering. Well, I am here as a witness, but of course, as I have indicated to the court, roughly actually this time last year, that I actually should have been the defendant on this trash code enforcement type of complaint.
What?
And not only back then have I expressed my regret and have been at least been remorseful about the whole situation. I also believe at least of this, not only this current case, but the case that has ended just back in April.
Let's pause for a moment. Mr. Altenberg standing. Mr. Altenberg, your objection?
Yes, Your Honor, Mr. Laauo is going to be testifying, or it sounds like he's about to testify to a separate case altogether that isn't part of this proceeding. And furthermore, it sounds like he is testifying to his insertion of whether or not Ms. LeCompte was guilty of the alleged violation or not, when in reality it was already determined.
I'm going to overrule the objection to the extent it has to do with whether Ms. LeCompte is guilty or not of the other charge. I certainly would sustain it, but if there's information pertaining to the circumstances of the property, whether it was the front yard from a prior case or the backyard from this case, you can talk about that.
Thank you, Your Honor.
But
Because
keep it focused on the property itself.
yes, Your Honor. Thank you, Your Honor, because prosecutor actually brought up your order on, was it April 22nd or April 23rd repeatedly, just now in the cross-examination of Ms. LeCompte. But if I may continue, I have been the one person and the only person truly responsible for all these so-called loose items or trash items accumulation.
They planned that. They planned it. Put it in the comments.
And in many,
Right.
and actually, that actually started at around November/December of 2023, when I was informed by a real estate agent that the neighbor house would be evicted, and based on my bad past experience with the neighbor on the south, I created barricade. Some of these I have already conveyed in writing to the court and asked to be a defendant, not only on the previous case, but I've consistently expressed that I should be the defendant in even the current case, and most likely in what Mr. Altenberg wants to keep bringing
I
up.
want you to
as the
talk
new
just about
case.
the state of the property and your role in the state of the property, not diving into
Thank you, Your Honor.
whether someone should be a defendant or not.
Yes, I should, um, once again, I am sorry for truly the overall appearance and also the feelings, the hurt feelings, or maybe worse, much worse than hurt feelings by the neighbors and so forth. But of course, I am also very sorry to Ms. Lacombe for, I guess, overlooking my own personal problem, my various issues, especially over the time that she was unable to. But the court, whether it is this specific case and in even the related earlier case, have at least, if nothing else, seen that I have made progress towards cleaning up, and at some point actually been able to do in what I may even say a fairly acceptable job. Have I not at times lapsed into, oh, I need to move more stuff, so darn it, I have to unload certain things, but unload certain things in a way that it hopefully would be a short-term thing. So have I not lapsed into that, I guess, problem? I definitely must have. But in the general terms and scheme of things, there has been improvement, removal of stuff, not necessary to the, even by my own certification, not 100%, but at least hopefully a passing grade, maybe just to me. I'm sorry, you were objecting or?
Oh, no.
Oh, sorry, you.
You can continue, you can continue.
So
Maybe it would be helpful if I asked you some questions.
Why don't you? Because at this point, it's really just rambling. from
Yeah,
Mr.
sorry,
Laauo.
yeah.
So if you have questions, you can
And
ask.
we may not have the time to. Yes.
So the first question I'd like to ask you, Mr. Laauo, is could you give if you are responsible for this, and then, or if you would like to take responsibility for this, then can you give a date certain that by which you think this cleanup can be completely achieved?
I just stuck a poll in the chat. See how this whole thing just flipped? Now, I ain't gonna lie, I didn't watch all this yet. That's why these reactions are real, because I'm like, well, all of my reactions are real, but this whole thing turned around. Now it seems like Mr. Laauo is the one being questioned about everything, and this is messed up.
First of all, I definitely would admit to that I am fully responsible for
That's
all
not the
this.
question I asked. I
However,
wanted a date.
on the date,
Huh?
I would really, of course, like to be able to confirm a certain date as well, and it's a near-term date. But my only challenge is that we have a new prosecutor now. Previous prosecutor have been shifting
Okay, Mr. Laauo,
requirement.
would you please answer my question? Which
Will I
is,
commit to
can
a
you
specific
give me
date?
just an estimate. I don't want a specific date, but how many weeks, months do you think that this will take?
I can only say on true experience, near term, the last trial that was concluded was April 20-something. And today is August, beginning of August. So, so we are in less than a 4 months time span that at least there has been additional significant progress. So as
Just what is needed to be remediated right now?
She is scaled
That's my
up.
challenge. Prosecutor keeps shifting
No,
the,
Michael, please just answer
Oh.
what your estimate of doing what is there now.
She has scaled up. Michael, Mr. Laauo is his name. You don't call him that.
oh, sorry, that would be the north side of the backyard. And that would be absolutely no more than 2 months.
Okay, my next question is, can you please then tell the court what measures you will take to make sure that nothing keeps returning to the places that have already been cleared?
What?
I will try to answer, but I want to qualify because the court is aware of my previous encounter, or maybe ongoing encounters with boulder parking. And I have been able to minimize and
I'm talking about
mitigate
the
that.
property
No,
tonight,
so
not
yes,
your
so likewise, I have been doing maybe what I believe is sufficient and maybe unfortunately what other people may perceive as insufficient as to a cleanup. But it is definitely my genuine and my legal responsibility to ensure that things do not return.
Okay, thank you. Can you please describe for the court what your disposition will be, what are plans for the trucks that are, and trailers that are in the driveway? And an estimated departure date?
The court may recognize quite a few of those vehicles from previous, the 100+ parking tickets and
Laauo, would you
warnings that I
please
have.
just talk
So
about
those have been recently returned, but they are on the driveway.
No, but they need to disappear from the driveway. Can you please let me know what your plans for making them disappear from the driveway so that the other residents, that is me, can park in the driveway?
Thank you. Thank you for clarifying. While I do believe those vehicles on the driveway is not a Boulder Police Code enforcement issue at all, I actually, of course, have to definitely respect you as the property owner. So in what I have already committed to in the 2 months period for the north side of the backyard, I will also commit to during this same 2 months period that the other vehicles that are currently on the driveway, on the pointy side of this, on the west side of the house, those will be gone as well.
Okay. Would you please explain why it is that you have delayed so long in accomplishing the front yard, driveway, backyard, and north side of the house cleanup?
That's not gonna be relevant. That won't be relevant. It won't be relevant to me.
Okay.
Your actions as a defendant are relevant, but his actions are not relevant.
Okay. Your Honor, I was simply looking for a reason to explain what has been the inexplicable to me behavior of collecting things and leaving things in the property and that sort of
Understood.
thing.
Understand why. But I don't want any further from him because it's not relevant to my interaction with you as a
Okay.
defendant.
Okay, that's a
Then I
good
have no
one.
more questions.
Okay. Any questions from you, Mr. Altenberg?
Yes, only two matters I'd like to address real quick. Mr. Laauo, you were posed the question of when can this be achieved? And you noted that you've made progress towards cleaning up. You heard testimony today that the residents of 290 Pawnee have had multiple conversations the neighbors have had multiple conversations with 290 Pawnee about having the matters addressed in which you provide a date, and then according to the testimony, the entity in question was never cleaned up or the items in question were never picked up.
Sorry, you are referring to Jason Strauss,
Yes.
the immediate neighbor?
Mr. Strauss's testimony.
Yes. Okay.
Is there anything that would help push the fact that your statements today are indeed the time that you will be having this cleaned up?
Given no health or financial limitation on my part, I don't see the 2 months period as not being achievable, but I'm not too certain what you're asking.
I apologize.
Do I have to do a blood oath?
No,
I'm sorry.
that was just on my end. We can negate that question if necessary, Your Honor, due to.
You can move on.
But to address the second aspect of it, you mentioned the 2 month period to have the, which, was it the entire property or just a specific portion of the property cleaned up?
Don't know how to answer your question because your predecessor, Chris Reynolds, keep shifting the requirement. However, I have specifically mentioned under oath, north side of the backyard. I believe, and of course I admit to those are still my equipment, my property. And so I don't know what else, what are other things. Oh, of course, if you're referring to the vehicles on the driveway, I've already testified as what I've already made the commitment during the same 2 months. So are you referring to additional areas or the church that I need to be concerned with?
No, the question was whether or not the 2 month period was applying to a certain specific portion of the property or the property as a whole. If I am able to read your answer correct, are you saying that it'll take you 2 months to have the entire property cleaned up, so both the backyard and the driveway? Or is it just 2 months?
Sorry, so Your Honor, once again, prosecutor is trying to define what the whole property.
Let me clarify here. It's not going to be what plan Mr. Laauo has. It's going to be the sentence that the court imposes. So we're getting into a black hole here over something that won't really be as pertinent as what I've ultimately decided is going to be the sentence in the case.
Understandable, Your Honor. If that's the case, I only question Mr. Laauo. If you give a 2 month time period, is there a reason why the photos today show the active noncompliance on July 31st, and the difference between that and the photos provided today of only there being less than a week time period of that massive amount of change?
The court did not admit, I believe, the photo that I took that will probably surprise Officer Cochran, trying to conduct City of Boulder code enforcement business out of uniform, no body cam, no whatever.
Why are we talking about that? How's that responsive to his question? His question is how come things change so
on the
dramatically?
specific things, on one of the picture you show that Officer Cochran took next to the mailbox was stuff that I tried to donate and give away, yet Officer Cochran is the one who ticketed me for littering, and I will be appearing in this courtroom next week. So that's why it was there on the property to be given away, and since there were no timely takers, now it has been removed as well. So my dilemma was not being able to remove it to a donation place quickly is because I was ticketed for littering. And Your Honor, I will be in court with you next week on this.
Any other questions,
No
Mr.
more
Altman?
questions, Your Honor.
All right, you can step down, Mr. Laauo.
Thank you. Thank you, Your Honor.
You're welcome. All right, that's the evidentiary portion for the hearing. Let's have closing statements for sentencing. Each party can make an argument as far as what the sentence should be. Go ahead, Mr. Altenberg.
Yes, Your Honor, we believe that the evidence provided today shows a clear sign of continued noncompliance. On March 3rd, 2025, Ms. Lacamp's property was not in compliance as determined by the court on the July 3rd, 2025 trial. But on the July 3rd, 2025 date, Ms. Lacamp claimed that her property was at that time in compliance. Then on July 31st, 2025, photos were provided showing active noncompliance once more. And then Ms. Lacamp today provided photos showing that as of this morning, the property was, in her opinion, in compliance, or at least proceeding towards that. This cycle is that one that from testimony from Officer Cochran and Jason Strauss has been ongoing for years and has brought the neighborhood to a breaking point. And the defendant, Ms. Lacamp, and the 290 Pawnee property should not be permitted to avoid an appropriate sentencing by pushing the burden or pushing the blame from herself onto her significant other. The people ask the court to, at a minimum, follow the sentencing recommendation that we have submitted to the court because we believe that this is the most minimal sentencing available that would ensure an active cleanup of the property and further continued compliance of the property as well. There's legitimate worry that even though they might come into compliance, that future non-compliance is right around the corner. And we believe that the suspended punishments in the sentencing recommendation are necessary to finally require this proactive action by the defendant in the 290 Pawnee address.
And can you tell the court when that sentencing recommendation was submitted? I'm looking for it in the system.
It's not submitted yet.
There was one May 7th. Is that the document you're talking about on May 7th?
No, Your Honor. I was under the assumption. I will be uploading it right now, is my understanding. I may have avoided it. I did that so earlier.
And you can summarize it for the record just so we're clear.
Yes. For the purposes of the record, Your Honor, it is a request of no new violations involving the 290 Pawnee address, code violations generally, and Ms. Lacamp for 24 months. That over the course of the next 2 weeks, Ms. Lacamp and the defendant or the 290 Pawnee property is subject to photos of proof of progress showing the cleanup procedure. This will occur once at the 7-day period where these photos showing before and after, showing active progress will be provided to the court. Once again on the 11th day, and by the end of week 2, so approximately mid to late August 2025, all of the surrounding used property, surrounding the property is permanently removed for the 2-year period, 24-month period. To ensure that there is active compliance in compliance with this, the city recommends the fine amount of $26.50 per violation, so the maximum amount as per the City of Boulder Code, suspended on these conditions. So that would be $5,300 total. And
Suspending all of that?
suspending on the adhering to the conditions. In addition to that, Your Honor, the city recommends 70 hours of community service per violation suspended on these conditions, totaling a total amount of 140 hours. And Your Honor, because we are legitimately worried about the fact that there wouldn't be compliance based off of the history in question, the city also recommends 1 day of jail per violation suspended on these conditions, totaling 2 days of jail.
Okay, so let me summarize that so that Ms. Lacamp understands what you're recommending, and then if you want to upload that document, you're free to do so. You're not required to, but what the city has recommended is that I impose a total of $5,300 in fines and suspend all $5,300 in fines, impose 140 hours of community service, suspending all 140 hours of community service, and imposing 2 days of jail and suspending 2 days of jail on the condition that the defendant get into compliance over the next 2-week period, and then that remain in compliance for a 24-month period. Is that correct, Mr. Altenberg?
Yes, Your Honor.
Okay, so that's the recommendation from the city. The court has full discretion to impose whatever consequence it believes it is appropriate, but that's the recommendation from the city. Ms. LeCompte, your turn to make a sentencing argument.
Excuse me. Okay. I want to begin by saying I don't want to be a neighborhood pariah, and I would really like I want to live in peace with my neighbors, and I would really like for the cleanup to be done very quickly and for the conditions to never return. I've laid out before the court a plan for how I will get this done and what I will do if the obstacles and delays remain in doing so. I have been declared by the judge to be in compliance with regard to the front and both sides of the yard.
Sherdell, thank you very much for the super chat. Release Mr. Laauo. Oh, Marge work alone. Yeah, he got thrown under the bus for real. And they planned that because he came right in and testified that it was his fault. He hadn't said that the whole time. So they planned it.
The north and the north side and the easement side, and also to the front yard in the previous court case. And at issue, at least initially, was only the backyard, which is the subject of the case number 1045. I have provided evidence that that is well underway, and the back half of that property, of the south side of the yard, has been cleaned up, and there has been continued progress made on the cleaning up the north side, and any further offending items that were located in the photographs being shown today by the prosecution have been removed. There are still, I admit, issues, there is still trash in the backyard that needs to be removed, so the process is not finished. You have heard that Mr. Laauo, who I rely on to help me do this, said that he could probably get this done within a set period of time, which he stated was 2 months, and I will hold him to that.
See, she said help her do it, which means it's her stuff, because she's not saying Mr. Laauo needs to get his stuff off my property. See, that's the catch right there.
I can only offer my word that this will happen, but the remedy for not having it happen is for me to go ahead and pay to have a trash hauler remove all of these objects immediately at what I believe will be at great risk to myself. I find the fine, the community service, especially at my age when it's difficult for me to find opportunities to do community service, not that I wouldn't be willing if I could to do that. My past experience has been that it's been very difficult for me to do that, although I have complied with what I was required to do before. And I find putting me in jail would be unreasonable and cruel. So, and it would also very much impede my ability to continue to get this job done, which would be my objectives and which I think the neighbors would certainly prefer. And so I can only beg that the court would recognize my efforts to begin with, and also my total distress at not having been able to comply completely and in a timely manner. And I can only pledge that I will try to remedy that myself and overcome my ability to confront the hard decisions I've had to make to get here. So thank you.
All right, thank you, Ms. LeCompte. I'm going to take about 2 minutes. I'll just go off camera for a moment or two. I just want to compile my thoughts, and then I'll come back. I'm not leaving here. I'm just going to...
He went back to yell for a couple of minutes and came back.
All right, we're back on the record in case number 2025-1045. We've had the sentencing hearing today. The prosecution has made a recommendation for sentencing Ms. LeCompte just made a comment about the sentencing recommendation. The court has now conducted the hearing, heard all of the testimony. I want to point out that this case started back on March 5th of 2025. There was a People's Exhibit 5 that was introduced at the trial that showed the property as of March 5th of 2025, specifically the backyard. Where we're focusing here today, initially at least, is on sentencing based on the violation that occurred in the backyard. And the People's Exhibit 5, and if you don't mind, if you can find that from the trial, Sabrina, People's Exhibit 5 is very clear. It showed a tremendous amount of debris and trash accumulating in the backyard. There was no question in the court's mind that there was a violation that occurred on March 5th, 2025. The purpose of the sentencing hearing, from my perspective, was to allow the defendant an opportunity from the trial date, which occurred on July 3rd, to today's date, which is about 5 weeks later, to allow the defendant an opportunity to come into compliance so that what was displayed to the court as of March 5th, and which continued to some extent even at the trial on July 3rd, the court's hope would be that there would be full compliance with no debris on the backyard and no debris on the front yard. Because simply moving it to the front yard, defendant was already under a court's order to stay in compliance for 24 months. With respect to the front side of the property, that's in another case. So moving what is debris and trash accumulation from one area of the property to another area of the property that's already subject to a court's order doesn't work in the court's mind to alleviate responsibility. What the court wanted to see was that, in fact, all of the property that was considered to be trash was moved permanently from the property, not to another space on the property, or not temporarily to a parking lot and then moved back. And that has not happened. That's clear to the court. The evidence that's been provided comes from the exhibits that were offered by the prosecution at this hearing, most notably People's Exhibit 9, but the other Exhibit 9 shows a little bit of the backyard, that there's still quite a bit of items in the backyard. Not a very detailed photograph, but it certainly gives the court a perspective enough. But also the testimony from Mr. Strauss, who has lived adjacent to the defendant for some period of time, and what he described as basically property moving back and forth from the property and then into various areas of the property. And so, although it wasn't a lot of testimony from Mr. Strauss, it certainly convinced the court that this is, there have been at least a number of conversations that have occurred where Mr. Strauss was told that the property would be cleaned up, and that the property wasn't cleaned up, and that he doesn't believe that the defendant truly appreciates the scope of this problem as it impacts him and perhaps other neighbors in the area. But what is clear to me, and from the heartfelt testimony of Ms. LeCompte, is that she has not been in control of this situation. And so she now needs to be in control of this situation, and she will be accountable at this juncture for not being in control of the situation. There was a recommendation from the prosecutor in this case to impose a $2,650 fine on both charges and then suspend all of that. I'm actually going to be a little, it's very rare that I do this, but I'm going to actually impose some active fine. I'm not suspending all of it. I'm going to suspend $2,200 of the fine on each of the charges, but there'll be a net $450 fine on each of those charges. So it'll be a $900 net fine plus $30 in court costs that the defendant will be required to pay. The other $4,400 in fines will be suspended for 24 months, and it will be on coming into compliance and staying into compliance for that 24-month period. Mr. Altenberg, on behalf of the prosecution, set forth a schedule for perhaps photographs and things of that nature. I'm not sure if I believe that that's very helpful. What I will be doing is giving a date certain by which this all has to be done. It's going to be very clear. It all has to be done. But I also want to point out to you that moving it somewhere and then moving it back won't satisfy, because it may work in the short term, but now you've got a code enforcement officer who's here in the courtroom hearing the judge say that if there's property that gets moved back, leaves the property for by the date that I set, and then comes back a few days later, It's going to be his job to let the prosecutors know, and they can file a motion for contempt. They can ask the court to hold you in contempt and bring you back in so that I can reimpose penalties, not just for the backyard, but also in the criminal case number 2024-2250. You're on probation for that case still. You're on a suspended sentence on that case for 24 months from October 8th of 2024 all the way to October 8th of 2026. So if property gets moved to the front, that's a violation. If it's trash that gets moved to the front, that'll be a violation of that order. And vice versa. If you get the front, if you keep the back clear and then you move it all to the front, then you move it all to the back, that's going to be a violation of today's order. There is nowhere left to go with this property. It has to be removed. And what Mr. Laauo has convinced me of, hopefully he's convinced you of this, Ms. LeCompte, he's not going to be able to do it. I'm sure it's really, really painful for you to hear that, but he's not going to be able to do it. He's shown you that. He's shown you that over a course of a long, long period of time that he's not capable of doing it. And that's sad for me to say because Mr. LeCompte appears to be a nice person, but he's got an issue with moving property and taking property onto your land. And he's not going to be able to comply no matter how much he likes you or cares about you and how much of a history that you have. He's not going to be capable of doing that.
He said, Mr. LeCompte.
So if you wait for him to do that, you're going to be out of compliance because I can't wait. Your neighbors can't wait. The people who have participated in this process for 2 years or plus cannot wait. So on this case, I'm suspending $2,200 on each count. It is extraordinarily difficult for me to say that I could even consider putting a person your age in jail. I do not like the idea of that. And yet I don't know what else to do because the only authority I have is for jail, community service, and fines. Those are really the only options I have. I've already suspended most of the fine. I'm going to suspend a 2-day jail sentence, 1 day on each of the charges on the condition that you come into compliance. And I'm going to give you a deadline here in a moment. And I'm going to suspend 60 hours of community service on each charge for a total of 120 hours, again, on that you come back into compliance. 2 weeks is probably too short. 2 months is way too long.
Yep.
I want to give you the opportunity. This cannot, Mr. Laauo gets it all moved by the time you've hired people to come in and take it all to the dump, so be it. But you need to understand it's not going to be about Mr. Laauo. It's about you. And so you need to make plans now to get that property into compliance. And I'm going to give you 3 weeks. I want it in compliance in 3 weeks. That's a lot of time. That allows you to call folks to do it right away. And if that means towing vehicles that have junk that's protruding outside of the vehicle. Now, if the vehicles are legally parked on your property and they're not a violation of any other ordinance, fine. But and I'm talking about vehicles that might be in your driveway. But if they're protruding trash, then they may not be in compliance with my order. And if there's items of trash that get moved to the front of your property, that may not be in compliance with my last order. So I want to make it really clear to you, it all has to be gone. And that's 3 weeks from today. And today's
6, so you're looking at the 27th.
the 27th of August. And let me just look at our calendar. We don't have to have a hearing scheduled for the 27th. It'll make it just be simply clear to the folks involved with this. Code enforcement can say, they're going to go over there on the 27th. I'm pretty sure they'll schedule it and they'll go over and they'll look and see, is the property in compliance? And when I say 27th, I mean by 4 p.m. on the 27th of August. If it's not in full compliance by that date, then you will have the other $2,200 to pay on each of those charges. You'll have the 120 hours of community service to perform on, and then you'll face the possibility of the 2 days of jail. I'm not sure that I'm going to have you make that active jail for you. I've suspended it right now, but it's quite possible you could spend a weekend in jail on top of everything else. What I'm trying to do is make it clear to you, Ms. LeCompte, that any pity or concern or desire that you have to maintain that relationship with Mr. Laauo that puts you in a position of not pushing this forward right away is subjecting you to the penalty of going to jail and the penalty of having to do 120 hours of community service and having to pay another $4,400 in fines and costs. I can't think of anything more painful for me to say someone of your age and to Mr. Laauo, who has obviously been your partner for a long period of time. But I'm also faced with a community of people who are really distraught about this. And that's been represented by Mr. Strauss's testimony today, but also by the information that's been shared during the testimony during the trial, that this has been an ongoing problem. It's a significant problem for the community, for our entire community, for it not to be resolved. So I have no choice. At some point, I simply have to hold you accountable. And hopefully that will allow you to say, this isn't about me, to your good friend and the person that you've been close to for so long, Mr. Laauo, say, it's out of my hands now. It's not in your hands anymore. You can't let him do what he's doing because you've enabled him and you've put yourself in a position of now paying the consequence for enabling him. So that'll be my sentence. There won't be a hearing scheduled on the 27th. It will be up to the prosecutor's office to file a motion for show cause if there is not full compliance. And it would have to be in two separate proceedings, perhaps, if there's violations of the court order in 2024, 2250, it would have to be a show cause motion in that case. And if there's a violation of the circumstances in case number 2025-1045, it would be a show cause order in that case. I'm requiring you from coming to compliance on the new case, but there's nothing that stops them from looking at the front of the property and saying you're not in compliance. It would make sense for them to look at both parts of the property on the 27th of August, taking pictures of both parts of the property. And that's what I'll rely on. It won't be what you take on August 28th or 29th or 30th or September 1st, even if I have to set a hearing in mid-September. What I'll be relying on to deciding whether you go to jail or whether you have community service obligations or you have to pay the other amount of fines is how the property looks by 4 p.m. on August 27th. And that means you may need to call haulers right away so they can get it all done.
Okay, thank you, Judge.
Okay,
I do have one question.
yes,
And this may seem a picky question, but you said that vehicles that are properly licensed and in the driveway are okay. Does that mean anything? I know that you can't have trash and tires and things like that stacked in the vehicle. I understand that. But do the vehicles essentially, like a truck, have to have a totally empty bed? And I'm asking that for clarification for other reasons.
I'm not versed enough in the code to tell you whether or not items that are inside of an empty bed would be a violation. My guess is they would not, but you need to discuss that with code enforcement as to whether or not they would consider that something that they would ask the prosecutor to base their show cause order on. I can't say that to you with certainty at this time. You have to be in compliance with the law. And because there are so many different aspects of the law that apply to that property, as you've already discovered, I'm not going to pass judgment in this moment of sentencing. I'm just going to tell you, if you have questions, either hire a lawyer or have a conversation with Mr. Cochran as to what's permissible in the front of your property. For example, a vehicle that could be considered an abandoned vehicle that doesn't have a proper tire on it could be considered a violation. I'm not saying whether it is or not, but that's something you'll be discussing with code enforcement.
Thank you.
It's a fair question to ask. I'm not going to have you pay the net fine today because we've already closed up the back office. So I'm going to have you a due date for it. Remember, August 27th is the due date to come into compliance. That'll be the same date that your fines and costs are due. I'm not staying them; they're just due that date. You have to pay them, but it'll be a total of $930 that will be due. August 27th by 4 p.m. So you can call Sabrina here at the court and pay any time before then, or to call anybody at the court and pay before that time, but it would be due that time at that time.
And that is for case 1045?
1045, yes, that's right. Okay, any questions from you, Mr. Altenberg?
No, Your Honor.
Any additional questions from you, Ms. LeCompte?
No, Your Honor.
Okay. I'm sorry that we're in this situation. I know you're sorry. I'm quite certain that many folks are sorry that we're in this situation, but my hope is this will be the last interaction that you and I have. We do not have to have any more. If you can get this property into compliance, and look how beautiful it was. And you want your legacy. At some point you aren't going to be here. I'm not going to be here. Don't you want your legacy to be, this is a beautiful property. Return it to what it can be. And you may have to spend some money, get some people to take that, the items that are on that off the property, disposing of them in trash or wherever it needs to be done. You may just have to bite that bullet. And that may be very, very hard for you to say to Mr. Laauo, but your legacy for that property for 34 years is on the line here. And you have it, the power within you to bring it back to where it needs to be.
Yes, Your Honor.
Okay, all right, we will go off the record.
He is off the record. Well, that was definitely a shocker how things turned out in this hearing, especially when she got up on that stand and threw Mr. Laauo under the bus, which they planned. I know they planned it. Y'all can let me know what you think in the chat. They planned that. That went too smooth. He wasn't shocked or anything. He's like, oh, I did it all. They talked about it. That's her stuff. And that's her stuff out back. So I think Mr. Laauo may be up next. We're going to mess with Mr. Laauo for a little bit. So I'm glad that everybody hung out and watched this tonight. I enjoyed it. I had a good time. Hope you had a good time. And thanks for coming by. I appreciate all of it. So, okay, we'll figure out when I'm going to start Mr. Laauo up. And we're going to take it from there. So I hope y'all all enjoyed it. And thank you once again for being here. And I'll see you around on the next one. All right? Y'all have a good night.